of Social Development and others for judgment.
Thank you.
Chief Justice, Deputy Chief Justice, and all the justices, I appear on behalf of the first, second, and third respondents.
Thank you. I thought you would tell us who you are.
Mabatu Kharia.
Thank you. Yes.
Chief Justice, Deputy Chief Justice, Justices, I appear for the fifth and the fourth respondents. Mr. Tsetlo.
Thank you.
Chief Justice and all the justices, I'm Angasha Tabata, and I appear on behalf of Cash Paymaster Services, the sixth respondent.
Thank you.
Chief Justice, Deputy Chief Justice, Justices, I am Cecilia Marile, and I appear on behalf of the Information Regulator.
Thank you too.
Chief Justice, Deputy Chief Justice, and the rest of the justices, I'm Sidisa Gaba. I came to know the judgment on behalf of Amicus Curiae, the post office.
Thank you, ma'am.
As the court pleases.
Chief Justice, Deputy Chief Justice, and other justices, my name is Karabo van Heerden, and I appear for Corruption Watch, the amici in the matter.
Thank you, ma'am.
Chief Justice, Deputy Chief Justice, and the Chief Justices. My name is Simon Kunene, and I act for freedom under law.
Thank you.
One of the signature achievements of our constitutional democracy is the establishment of an inclusive and effective program of social assistance. It has had a material impact in reducing poverty and inequality and in mitigating the consequences of high levels of unemployment. In so doing, it has given some content to the core constitutional values of dignity, equality, and freedom. This judgment is, however, not an occasion to celebrate this achievement. To the contrary, it is necessitated by the extraordinary conduct of the Minister of Social Development, Minister, and the South African Social Security Agency, SASSA, that have placed this achievement in jeopardy. How did this come about? The Constitution provides that everyone has the right to have access to social security, which includes, if they are unable to support themselves and their dependents, appropriate social assistance. In terms of its obligations to take reasonable legislative and other measures within its available resources to achieve the progressive realization of this right, Parliament enacted the Social Assistance Act, which makes provision for various forms of social grants. The Act provided for the establishment of SASSA as an agent for the administration and payment of social assistance. The CEO of SASSA is responsible, subject to the direction of the Minister, for the management of SASSA. SASSA may, with the concurrence of the Minister, enter into an agreement with any person to ensure effective payments to grant beneficiaries. On the 3rd of February 2012, SASSA concluded a contract with Cash Paymaster Services, CPS, to provide services for the payment of social grants for a period of 5 years. On 29 September 2013, this court held that the award of the tender was constitutionally invalid in the case of All Pay 1. It subsequently made a remedial order where it suspended the declaration of invalidity, and this declaration was based on the premise that either a new 5-year tender would be awarded after a proper procurement process, or that SASSA would itself take over the payment of social grants when the suspended contract came to an end on the 31st of March this year. SASA was ordered to report to the court on progress in respect of the new tender process and its outcome. In November 2015, SASA finally reported that it had decided not to award a new tender, but that it would itself take over the payment of social grants, and it would be able to meet the deadline of 31 March 2017. On accepting this assurance, this court discharged its supervisory order, but the assurance given to the court turned out to be without foundation. Since April 2016, the responsible functionaries of SASA have been aware that it could not comply with the undertaking to the court that it would be able to pay social grants from the 1st of April this year. The Minister says she was informed of this only in October 2016. There is no indication on the papers before us that she showed any interest in SASA's progress before that. Despite repeated warnings from Advising Council and CPS, neither SASA nor the Minister took any steps to inform the court of the problems they were experiencing, nor did they see fit to approach the court for authorization to regularize the situation. The Minister and SASA tells us that CPS is the only entity capable of paying grants for the foreseeable future after the 31st of March. This court and the whole country are now confronted with a situation where the executive arm of government admits that it is not able to fulfill its constitutional and statutory obligations to provide for the social assistance of its people. And in the deepest and most shaming of ironies, it now seeks to rely on a private corporate entity with no discernible commitment to transformative empowerment to get it out of this predicament. In a constitutional democracy like ours, it is inevitable that at times tension will arise between the different arms of government when a potential intrusion into the domain of another is at stake. It is at times like these that courts tread cautiously to preserve the comity between the judicial branch of government and the other branches of government. But there was no constitutional tension about social grants in November 2015. There was no legitimate reason for the court not to accept the assurance of an organ of state, SASA, under the guidance of the responsible minister, that it would be able to fulfill an executive and administrative function allotted to it in terms of the Constitution and applicable legislation. There was no threatened infringement to people's social assistance rights, and no suggestion that the foundation of this court's remedial order would be disregarded. Now there is. There must be public accounting for how this was allowed to happen. Accountability is a central value of our Constitution. It accompanies the conclusion of procurement contracts for the procurement of public functions. This judgment is the judicial part of that accounting process. It is founded on the commitment to openness and responsiveness the Constitution requires. It is important to note that this particular role, at this particular time, is not one of the court's own choosing. The sole reason for the litigation leading to this judgment is the failure of SASA and the Minister to keep their promise to this court and the people of South Africa. What needs to be understood, however, is that it is not this court's standing or authority for its own sakes that are important. Judges hold office to serve the people, just as members of the executive and legislature do. The underlying danger to us all is that when the institutions of government established under the Constitution are undermined, the fabric of our society comes under threat. A graphic illustration would be if social grants are not paid beyond 31 March. It is to the practical avoidance of that potential catastrophe that we must now turn. Black Sash brings its application in the public interest and in the interest of all grant beneficiaries to seek reinstatement of the oversight role of this court for the payment of social grants. It brings its application to ensure that SASSA complies with its constitutional obligations to provide social assistance in a lawful manner. That lodged an application for leave to intervene as a second applicant. It sought to make submissions and obtain relief aimed at further disciplining the process of the proposed arrangement between CPS, the Minister, and SASSA. Corruption Watch and the South African Post Office, SAPU, have filed applications to admit it as friends of the court. In a judgment written by myself, in which the Chief Justice, the acting Chief Justice Mogoeng, the acting Deputy Justice, Justice Nkabinde, Cameron J, Jafta J, Kampepe J, Mhlantla J, Mojapelo AJ, Pretorius AJ, and Zondo J agrees, the application for direct access is granted. Freedom under law is granted to leave to intervene, and both Corruption Watch and SAPU are admitted as friends of the court. In Orpe 2, the court held that the suspension of the validity of the contract between SASSA and CPS did not prevent the court from regulating and supervising both the content and performance of that contract. It did so on the basis that both SASSA and CPS were organs of state in relation to the contract, and that this entailed constitutional obligations for both entities. That this court's remedial power under Section 1721B2 of the Constitution allowed this, and that CPS also bore obligations under Section 8.2 of the Constitution because it had performed a constitutional function for a significant period already. That constitutional obligation persisted to ensure that a workable payment system remains in place until a new one is operational. The constitutional obligations of both SASSA and CPS as organs of state performing a constitutional function for a considerable period do not end on the 31st of March this year. Both SASSA and CPS accept that. SASSA failed to honor its assurance to this court that it will be in a position to make payment of social grants after 31 March. It and CPS failed to timeously conclude a lawful contract to provide for that payment. These circumstances provide a different context for the enforcement of a just and equitable remedy from that obtained when we made the remedial order in Orpe 2. The context then was a breach of the constitutional and legislative framework for fair, equitable, transparent, competitive, and cost-effective procurement. The constitutional defect now lies elsewhere. The primary concern here is the very real threatened breach of the right of millions of people to social assistance in terms of Section 27(1)(c) of the Constitution. It is that threatened breach that triggers the just and equitable remedial powers the court has under Section 1721B2 of the Constitution, not only the potential invalidity of the proposed new contract that SASSA and CPS seeks to conclude. The need to intervene under these and similar circumstances was aptly captured by Mogoeng CJ in the Mhlopi case in these terms, and I quote, "It bears emphasis that this is an exceptional case that cries out for an exceptional solution or remedy to avoid a constitutional crisis which could have grave consequences. It is about the upper guardian of our Constitution responding to its core mandate by preserving the integrity of our constitutional democracy. And that explains the unique or extraordinary remedy we have crafted," unquote. This court's extensive powers to grant a just and equitable order also permitted to extend the contract that would otherwise expire on 31 March. Since the contract was declared invalid in Orpe 1, if we extend the contract, it will be necessary to also extend the declaration of invalidity and the suspension of that declaration for the period of the extension of the contract. In OPE 2, we tied up the suspension of the declaration of invalidity to the period of the invalid contract. That was done in order to allow the competent authority to correct the defect and to avoid disrupting the provision of crucial services that it was constitutionally obliged to render. There was much debate during the oral hearing before us on whether it would be just and equitable to order that those reciprocal obligations should be the same as that of the contract that was to expire on the 31st of March this year. I consider that it should be. No party has any claim to profit from the threatened invasion of people's rights. At the same time, no one should usually be expected to be out of pocket for ensuring the continued exercise of those rights. That equilibrium was the premise of the court's previous remedial order. It is just and equitable to continue on that basis. Our order reflects that SASSA and CPS should continue to fulfill their respective constitutional obligations in the payment of social grants for a period of 12 months as an extension of the current contract. To the extent necessary, our earlier declaration of invalidity of that contract must be further extended, as well as the suspension of that declaration of invalidity. In the event that CPS wishes to alter the content of its financial obligations, the order makes provision for it to approach National Treasury for its consideration and approval, to be confirmed by this court after a report to it by Treasury. My brother Madlanga J wrote a separate concurring judgment, and as his judgment shows, there is another valid way of arriving at an identical outcome. In his judgment, Madlanga J accepts that this court has a wide remedial order to power to order CPS and SASSA to fulfill their obligation of paying social grants. However, Madlanga J finds difficulty in the convoluted way of first extending the contract, presumably with the extension carrying the original invalidity, and only to then extend the suspension of the declaration of invalidity. Madlanga J sees no bar to making a direct order to the effect that, in terms of the court's wide remedial powers, CPS has to continue paying social grants. The Minister bears the primary responsibility to ensure that SASSA fulfills its functions. She appoints its Chief Executive Officer. There is little that the CEO can do without her direction. Attempts to obtain evidence of what steps she took after OPE 2 to ensure that beneficiaries would continue to be well catered for drew a blank. These aspects require further scrutiny, but that can only be done after the Minister is joined to the proceedings in her personal capacity and given an opportunity to explain her conduct in relation to these issues. In the result, the following order is made. 1, the Black Sash Trust is granted direct access to bring this application. 2, Freedom Under Law NPC is granted leave to intervene. 3, Corruption Watch, NPC, RF, and the South African Post Office, SOC Limited, are admitted as friends of the court. 4, it is declared that the South African Social Security Agency, SASSA, and Cash Paymaster Services Pty Limited, CPS, are under a constitutional obligation to ensure payment of social grants to grant beneficiaries from 1 April 2017 until an entity other than CPS is able to do so, and that a failure to do so will infringe upon grant beneficiaries' rights of access to social assistance under Section 27(1)(c) of the Constitution. 5, the declaration of invalidity of the contract is further suspended for the 12-month period from 1 April 2017. 6, SASSA and CPS are directed to ensure payment of social grants to grant beneficiaries from 1 April 2017 for a period of 12 months on the same terms and conditions as those in the current contract between them that would have expired on 31 March 2017, subject to these further conditions. 6.1, the terms and conditions shall A, contain adequate safeguards to ensure that personal data obtained in the payment process remains private and may not be used for any purpose other than payment of the grants or any other purpose sanctioned by the Minister in terms of sections 20 sub 3 and sub 4 of the Social Assistance Act 13 of 2004. And B, preclude anyone from inviting beneficiaries to, quote, opt in, unquote, to the sharing of confidential information for the marketing of goods and services. 6.2, CPS may in writing request National Treasury during the 12-month period to investigate and make a recommendation regarding the price in the contract. 6.3, National Treasury must file a report with this court within 21 days of receipt of the request setting out its recommendation. 6.4, within 30 days of the completion of the contract, of the period of the contract, CPS must file with this court an audited statement of the expenses incurred, the income received, and the net profit earned under the contract. 6.5, SASSA must thereafter obtain an independent audited verification of the details provided by CPS under paragraph 6.3. 6.6, the audit verification must be approved by National Treasury, and the audited verification must be filed by SASSA with this court within 60 days. 6.7, CPS must permit the auditors appointed by SASSA to have unfettered access to its financial information for this purpose. 7, the Minister and SASSA must file reports on affidavit with this court every 3 months, commencing on the date of this order, setting out how they plan to ensure the payment of social grants after the expiry of the 12-month period, what steps they have taken in that regard, what further steps they will take, and when they will take each future step, so as to ensure that the payment of all social grants is made when they fall due after the expiry of the 12-month period. 8, the reports filed by the Minister and SASSA as contemplated in paragraph 7 must include, but is not limited to, the applicable timeframes for the various deliverables which form part of the plan, whether the timeframes have been complied with, and if not, why that is the case, and what will be done to remedy the situation. 9, if any material change arises in relation to circumstances referred to in a report referred to in paragraph 7 or 8, the Minister and SASSA are required immediately to report on affidavit to the court and to explain the reason for and consequences of the change. 10, it is declared that SASSA is under a duty to ensure that the payment method it determines, 10.1, contains adequate safeguards to ensure that personal data obtained in the payment process remains private and may not be used for any purpose other than payment of the grants or any other purpose sanctioned by the Minister in terms of section 20 sub 3 and 4 of the Social Assistance Act. And 2, precludes a contracting party from inviting beneficiaries to opt into the sharing of confidential information for the marketing of goods and services. 11, the parties are within 14 days from the date of this order required to submit the names of individuals with their written consent suitably qualified for appointment as independent legal practitioners and technical experts for the purpose referred to in paragraph 12 below. 12, the Auditor General and any person or persons or institutions appointed by the court after receipt of the names submitted under paragraph 11 shall jointly and until otherwise directed by the court, 12.1, evaluate the implementation of payment of social grants during the 12-month period. 12.2, evaluate the steps envisaged or taken by SASSA for any competitive bidding process or processes aimed at the appointment by SASSA in terms of section 42A of the Social Security Agency Act of a new contractor or contractors for the payment of social grants. 12.3, evaluate the steps envisaged or taken by SASSA aimed at SASSA itself administering and paying the grants in the future, or SASSA itself permitting any part or parts of the administration and payment processes in the future. And 12.4, file reports on affidavit with this court every 3 months, commencing on a date 3 months after the date of this order, or any shorter period as the legal practitioners and experts may deem necessary, setting out the steps they have taken to evaluate the matters referred to in paragraphs 12.1 to 12.3, the results of the evaluations, and any recommendations they consider necessary. 13, the Minister is called upon to show cause on affidavit on or before Friday, 31 March 2017. Why? 1, she should not be joined in her personal capacity, and 2, she should not pay costs of the application from her own pocket. 14, costs are reserved until conclusion of these proceedings. I hand the judgment down.
The court will adjourn.
Sure. Okay. Where is already? In case we get a guest. Gina, you need to set up in case we get a guest. Gina. Hello? Hmm? Hello? Yes, I can, Elvis. No, not yet. Okay, yeah, we have the SASSA CEO. Just, do I have someone here? Okay, yeah, let's come. Can I have you on this side, on this side? On which side should he be? On this side. Okay. 1, 2, 3, 1, 2, 3. Well, Elvis, as expected, we have that ruling that has been handed down, and it came as no surprise that the Constitutional Court found itself in a position, as Justice Froneman has indicated, where he quoted Chief Justice Mogoeng to avoid a constitutional crisis, and the ruling is that the contract with the CPS, between CPS and SASSA, has been extended for 12 months. Of course, there are strict conditions that are placed on that, and that amongst it is that the personal details, the private details of SASSA beneficiaries are not to be shared, with anyone, and that information is not to be used either than making sure that people receive their grants. There's also been an order that's been handed down in terms of trying to get SASSA to build its own internal capacity to ensure that it's able to distribute those grants. And right now I'm joined by the CEO of SASSA. Thank you so much for joining us this morning. As expected, the contract has been extended. Of course, the invalidity also suspended for the next 12 months. What does this judgment mean for SASSA, Mr. Makwaza?
As always, what we've been saying all along, that beneficiaries will be paid on the 1st of April. Beneficiaries will be paid on the 1st of April. We've been speaking with National Treasury. They've already transferred the money over to us on the money that's supposed to be paid over to the beneficiaries. And on our side, yesterday I sat with my executives. We decided that before even the judgment came, we started pulling the trigger, like as usual, that it was going to be business as usual for us going forward. Because when we're listening to the judges, when the process was going on, we felt that the court is leaning towards what I've been asking for. I asked for 12 months, I got the 12 months. I asked for the extension of the contract, I got the extension of the contract. And as a CEO of SASSA, I am proud to be associated with SASSA as it is right now, and associated with my executives. All the executives that are behind me, they've supported me in everything that I've been trying to do. Now, I'm not going to say anything more. It's just that from now onwards, we'll be paying the same going forward. And the 12 months that we've been asked for will immediately start with the processes, either to get the interim organization that is going to help us while we are doing all the processes to insource the processes for SASSA.
Do you think using the word proud is the right word, considering this crisis that we find ourselves in? Though probably the crisis has been averted. Is proud the right word to use at this point?
I can say it is the right word to use right now, because I started on the 1st of April. I mean, 1st of November. From the 1st of November when I started starting the ball rolling. And the ball has been rolling. All the things that has happened, the judges that I spoke about, are things that I've been praying for and putting in place with my executives, and it is happening.
One of the questions that was raised even during the hearing, in the arguments, it was around SASSA building its own internal mechanisms, and we spoke about it on Wednesday. And you did say that it was unfortunate that it didn't come across strongly that indeed SASSA is trying to get the capabilities to ensure that it has its own internal capabilities, and you have been in consultation with the CSIR.
Yes, there are so many things that we've been doing, and the issue of biometrics, the mere fact that the banking industry has adopted the biometric standards, it culminated from the processes that we've embarked on with the CSIR. But that has not been put forward, has not been communicated the way that it's supposed to have been communicated. And all the banks of this country, from last year June, adopted the biometric standards, and they are putting processes in place for us to be able to do what we are expected to do.
Does SASSA at all take culpability of what has transpired?
No, we do. I mean, we dropped the ball during the time we advised in, I think it's May 2016, and nothing was done all the time, and except that the other process I was talking about. But on the issue that we are told that the SASSA may not be able to pay grants this year, and we did nothing on all the side, we apologize to the nation.
I just quickly want to go back to the issue around, you were saying that on the 1st of April, grant beneficiaries will get their money. I'm asking you this because we had a discussion with the CPS director, Serge Bellamont, who was saying that the more there's a delay, chances might be that the grants will have to be paid on the 2nd or the 3rd. But you say that you've pushed the button already, so you've circumvented the possibility of having to delay the day by which the grants are paid.
I do not want to argue with Serge Bellamont. I don't think that he was talking the whole truth, because he knows that the processes start on the 20th of each month. But the money is transferred from Treasury 3 days before we pay money. The money is over to the beneficiaries. But the processes on its own start on the 20th. Not on the 16th or the 15th, as he was saying. He was just playing ball as a businessman, trying to coerce us into a space where I don't think that we wanted to go.
You used the word coerce. Do you think that the working relationship or the professional relationship between SASSA and CPS has broken down? But we have this declaratory order that says that SASSA and CPS has a constitutional duty to ensure that grants are paid for over the next 12 months.
It hasn't broken down. CPS is a company that is making profit. We are constitutionally obliged to pay the beneficiaries. So our relationship is the service provider-client relationship. So we do not drink coffee together. We do not do all those things. We are obliged by the Constitution to do what we are supposed to do. We are not happy with what Net1 and Net1 companies that are the holding company of CPS on using the information of the beneficiaries for the deductions. I, myself, have been co-chairing the MTT with the Black Sash and the civil society on the issues of the deductions. You know, it's an open secret that we went to court, we went to police station and charged those companies that were not doing what they were supposed to do. Net1 and their companies is one of the people that we cited when we went to court. So there is that portion within Net1 that we are not happy about. But on contrary, on the other side with CPS, to be honest with the country, CPS has done very, very well for us. As in, we have not a single time that we have failed to pay the beneficiaries. And going forward, I don't think that is going to happen. CPS is an organization that at present, under the circumstances, come 1st of April, we do not have any other company that will help us to do that. The court has just said that to us, and I'm happy because that's what I asked for.
Just a final question, how long will it take for SASSA to have its own in-house capability to make sure that grants are distributed?
I may not be able to say that right now. We need to sit down with the executive and sit down with other experts that we have to look into that. But 12 months is enough time for us to be able to go on a tender, if we've got to go out on a tender, to get other organizations that can be able to help us. There is an issue of the post office. We have not discarded that, and I'm on record on saying that the post office is capable. They may have not been capable to do it now on the 1st of April. But going forward, Mark Barnes says that they are ready. We are going to test that, and we've got enough time to do that.
Well, thank you so much. There you have it from the spokesperson, rather from the CEO of SASSA, Mr. Makwaza, indicating that on the 1st of April, grants will be paid. And as I've indicated that earlier on, a conversation that I had with the CPS director and Net1 CEO Serge Bellamont, he indicated that as it stands at the moment, they might have to delay the time that they pay the time that they distribute the grants by, probably by another 2 days. So we'll have to wait and see if indeed on the 1st of April grants will be paid. Mr. Makwaza has already indicated that yesterday already they started pushing the button to ensure that the money that flows from the Reserve Bank into SASSA's bank account and then into the Green Road bank account is then into the ATM accounts and into the bank accounts of those social grant beneficiaries. It's back to you in studio.